For a few days, the internet was buzzing with one bold claim that sounded almost unbelievable. Prince Harry had finally won his fight to get full, armed UK security back. Headlines spread fast, social media reacted instantly, and the narrative seemed locked in before anyone could even verify it. But here's where things get strange. No judge spoke. No court ruling was published. No official government confirmation appeared anywhere. Yet the story kept growing, evolving, and being reshaped in ways that made it feel less like a legal update and more like something carefully staged. And once you start pulling on that thread, the entire story begins to unravel in ways no one expected. It all started with reports claiming Prince Harry had scored a major breakthrough in his legal battle over security, with some outlets outright suggesting that armed police protection had been reinstated for his UK visits. The language was confident, almost celebratory, as if the case had already been decided behind closed doors. But the problem was immediate and obvious to anyone familiar with court proceedings. Legal wins don't appear through unnamed sources and speculative headlines. They come with judgments, rulings, and documented outcomes. Still, the headlines kept multiplying, and before long, the claim had taken on a life of its own, setting the stage for a story that would soon collapse under scrutiny. What many of these reports conveniently glossed over was the level of protection Prince Harry has been seeking all along. This wasn't basic security or situational coverage. This was top-tier, 24/7 armed protection at the same level as King Charles, Queen Camilla, and the Prince and Princess of Wales. Even senior working royals don't all receive that standard. Critics have pointed out that this level of protection goes far beyond what Harry would have received had he remained a working royal, let alone after stepping away. That detail alone raised serious questions because it reframed the issue from safety concerns into something much bigger and far more controversial. Almost immediately, the narrative shifted in a very specific direction. Suddenly, the issue wasn't just about security anymore. It became about family, reconciliation, and Harry's children potentially reuniting with their grandfather. Headlines began tying the alleged security decision to Archie and Lilibet, subtly suggesting that their presence in the UK hinged on this outcome. King Charles was quietly positioned as a possible obstacle, despite having no authority over Ravek or government security decisions. This emotional framing pulled at heartstrings while redirecting attention away from the central legal question, and that alone made some observers uneasy. A major source of confusion came from how Ravek, the Royal and VIP Executive Committee, was described in these reports. Some articles made it sound as though a new or special review had taken place, implying an extraordinary development. But in reality, Ravek conducts risk assessments every single time Harry plans a UK visit. This is routine procedure, not a concession or victory. By presenting standard protocol as a dramatic shift, the story created an illusion of progress where none had actually been confirmed, and that misunderstanding spread rapidly. As the days passed, one glaring issue became impossible to ignore. There was still no judge's statement. No appeal ruling. No verdict. Anyone who follows court cases knows that even minor procedural decisions leave a paper trail. In Harry's previous legal losses, judgments were published and widely reported. This time, there was nothing. That silence wasn't just suspicious, it directly contradicted the confidence of the headlines. And when legal stories don't come with legal documents, it's usually a sign that something isn't right. Eventually, quieter reports began to surface, carefully walking back the earlier claims. Sources familiar with the process admitted that the review was still ongoing and that no one actually knew the outcome yet. The once confident language softened into uncertainty, revealing that the original narrative may have been premature at best. The story that had been presented as a done deal suddenly looked more like speculation amplified into fact, and that shift forced many to reevaluate what they had been told from the start. This is where critics began drawing comparisons to previous situations involving Meghan and Harry. In the past, announcements about major deals, projects, or ventures were sometimes made before contracts were finalized or approvals secured. Observers argue that the strategy appears consistent. Put the story out first, generate public pressure, and let the attention force institutions to respond. While supporters dismiss this as coincidence, critics see it as a recurring tactic that blurs the line between aspiration and reality, especially when media outlets run with unverified claims. One of the most puzzling aspects of this entire situation is the intensity of the security fight itself. Public statements over the years suggest little desire to return to the UK permanently, and visits have been limited. That raises an obvious question. Why pursue such an extreme level of protection in a country that doesn't seem central to their future plans? For many observers, this disconnect is what turns curiosity into skepticism, because the legal effort doesn't appear to align with actual travel patterns or stated intentions. This is where speculation, clearly framed as speculation, begins to circulate. Some commentators believe the security case may be less about immediate safety and more about long-term status. There's been online discussion suggesting that being recognized as someone requiring state-level protection could have implications beyond the UK. These claims remain unverified, but they persist because they offer an explanation that fits the otherwise confusing behavior surrounding the case. Legal experts and court watchers have pointed out that courts take public misrepresentation seriously. If judges feel that their processes are being used as part of a PR narrative, it can damage credibility. Even if the misinformation didn't originate directly from Harry or Meghan, their silence allowed it to spread unchecked. For critics, that silence speaks volumes, because a simple clarification could have shut the story down immediately. Mainstream outlets played a crucial role in escalating this situation. Once one publication framed the story as a win, others followed, often citing each other instead of primary sources. This echo chamber effect transformed speculation into perceived fact, proving how quickly narratives can solidify without verification. By the time corrections appeared, the initial impression had already taken hold in the public mind. When everything is stripped back, the confirmed facts are surprisingly limited. There has been no ruling granting Harry full armed security. No appeal victory has been announced. RAVEC reviews remain routine and ongoing. Everything else exists in the space between interpretation, speculation, and media amplification. And that gap between reality and narrative is where confusion thrives. In the end, this story isn't just about security, it's about how easily perception can replace proof. A legal win was celebrated before it existed, emotional narratives were layered on top, and silence allowed confusion to spread unchecked. Whether this was a strategic gamble, a misunderstanding, or something else entirely remains open to debate. But one thing is clear, until a judge speaks, there is no verdict. And the real question now isn't whether Harry won his case, but why so many people were convinced he had before the law ever said a word.